been immersed in the First Amendment, particularly the free speech and free press aspects of it, literally all of my adult life. And so this is something that literally I started when high school journalist and moved into college radio and undergraduate, studied freedom of speech and freedom of the press. One of the great scholars of the day named Franklin Heyman, and then went on to graduate school and ultimately to law school and studied constitutional law at Berkeley, and then also had the privilege when I was there to also teach mass media law while I was in law school over in the Graduate School of Journalism at Berkeley. And then after finishing my formal education, I went to work in government and again confronted and dealt with many interesting free speech and free press issues, and continued in a variety of other contexts. Ultimately, obviously, I teach in this area, I write a good deal in this area. So that's my First Amendment background. But more critically, the reason for writing the book is the exploration I had and the ability I had to review 3,000 scrapbooks that were compiled during the life of Hugh Hefner. I don't know if many students know who Hugh Hefner was, but he was a great entrepreneur of the 20th century, started Playboy magazine and built an empire around that. He passed away 5 years ago. Last Saturday would have been his 96th birthday. And he had an enormous impact on American social and cultural life. He was also controversial in a number of other areas, but every Saturday of his life for over 75 years, he devoted to scrapbooking. So he basically every Saturday would put together things that happened to him that week and put it in a physical scrapbook. And he would also type out the captions for that scrapbook, and ultimately wound up with 3,000 leather-bound scrapbooks, which are now, I guess, the record holders for the Guinness World Record for the person with the most scrapbooks. His family and his personal staff have had access to the scrapbooks, but no one from the outside has ever been granted the ability to review the scrapbooks, particularly the full set of scrapbooks. And so I was afforded this wonderful opportunity to be able to see the scrapbooks and understand not only who he was, but his relationship to the First Amendment, and particularly the free speech and free press aspects of the First Amendment. And so that's where this book began. As I reviewed the scrapbooks, I also began to understand some of the critical areas that he had focused on, and also began to learn a lot about the Hugh M. Hefner First Amendment Awards. So these awards were established in 1979 by his daughter, Christy Hefner. And Christy ultimately became the president and then the CEO of Playboy, and was the CEO for 20 years, the longest serving female CEO of a public company in American history. Christy established the First Amendment Awards in 1979. They obviously continue. There have been 40 years of First Amendment Awards. There will be First Amendment Awards coming up this fall as well. And over that period of time, about 150 people have been given them in a variety of different areas. These are not all journalists and all lawyers. Many of them are courageous people who stood up for free press and free speech principles, whether they're school teachers or librarians or creative artists. So there are a number of really interesting people, and all of them are mentioned with brief descriptions in the back of the book. So you get a sense of this long litany of people that are connected to the First Amendment Awards and the Hugh M. Hefner Foundation. So the reason that Christy Hefner established these awards in her father's name was that in 1978, she had the Hugh M. Hefner Foundation, which was a not-for-profit organization, purchased the papers of John Peter Zenger. And I don't know how many people are familiar with that name, but John Peter Zenger is a legendary historical figure in free press literature and history, because he was a printer and a journalist in the 1700s. This is pre-revolution, when there was still the colony of New York governed by the British. And he published in his weekly newspaper, which is called the New York Weekly Journal, he published some articles which were highly critical of the governor, the royal governor back in England of New York. Ironically, that royal governor's name was Bill Cosby. But in any event, Cosby wound up suing John Peter Zenger for libel, for defamation. And so this is really probably the first major case testing the principle of freedom of the press in pre-United States, but certainly in the colonies. There was an extensive trial that was conducted, and John Peter Zenger was acquitted. So that precedent certainly was an enormous First Amendment precedent. The Hefner Foundation purchased these papers and then put them on display around the country. So it's a traveling exhibit of those papers. And in conjunction with that, a national contest was organized for high school students, what the First Amendment means to me. And the combination of the exhibit and the essays gave Christie the idea, maybe we should not just have this as an event for a year. Maybe this should be something that really becomes an annual event where we recognize the contributions, again, of a wide variety of people to First Amendment principles that were near and dear to her heart and obviously to her father's heart. So that's the shorter version of why the book got started. The last connection I'll give you here is that of those 150 people, many have been the seminal figures in free speech and free press law. And I thought it would be a good idea to try to capture them in very detailed, somewhat scholarly conversations, but conversations which obviously could be accessible not just to students or academics, but to the general public about their First Amendment journeys, about their thinking in this area, about what I call their head and their heart issues related to free speech and free press. And so I then began to travel around the country and conduct in-person interviews with 8 individuals. 7 of those had either nominated, judged, or received a Hugh M. Hefner First Amendment Award. The other person who I'll talk about a little after is Rick Jewell, who's a professor of cinema studies at the USC School of Cinematic Arts. And he stands alone for a special reason. And so in order to do this, I went back, Playboy magazine had pioneered a format called the Playboy Interview, which was a very in-depth interview, not a journalistic interview, but really something that was meant to explore how people thought and felt and reacted. And just an extraordinary group of people over the years have both conducted and been interviewed by Playboy magazine. Started in 1962. And the first Playboy interview was with a jazz musician named Miles Davis, who was quite legendary. It was conducted by Alex Haley, who went on to write a book called Roots, which many of you may be familiar with. So the idea behind the Playboy interviews was to not do this in a journalistic fashion, not just to have questions and answers, but to really make it into a conversation. And so in order to conduct these conversations, I literally read everything that any of these people had written, or whether it was a book or an article or a speech, Many of them had obviously have YouTube videos. And so in order to do these conversations, I basically had to learn a lot about what these people were thinking and then be able to go in to a conversation with them without any notes. And basically, we just had a free form conversation, which is in the book. We have, as I said, 7 really preeminent scholars and advocates, and then Rick Jewell, who also is preeminent in his area, which is the area of film censorship. So just briefly, the people are Jeff Stone, who is the former dean of the University of Chicago Law School and one of the preeminent constitutional scholars of our time. Floyd Abrams, who is one of the key, again, preeminent litigators, especially at the First Amendment level of free speech and free press issues, most notably the Pentagon Papers case, and of course, the commercial speech cases. So once upon a time, commercial speech was not considered part of the First Amendment. First Amendment was narrowly interpreted to focus on political speech. Floyd Abrams essentially argued the case that the Supreme Court decided that commercial speech as well as political speech would be covered by the First Amendment. Nadine Strawson is a distinguished law professor at New York Law School, but also the former president of the American Civil Liberties Union, the ACLU, the first female president. Burt Newborn, a distinguished professor at NYU Law School, also the founding director of the Brennan Center for Justice at NYU Law School, and the former legal director of the ACLU. And then David Cole, a distinguished law professor at Georgetown Law School, who is the present legal director of the ACLU. Lucy Dalglish, who's the current dean of the Merrill College of Journalism at the University of Maryland, who for many years was the executive director of the Reporters Committee for Freedom of the Press, which is one of the leading organizations that defends reporters' rights in court. And then last in that group is Bob Corn Revere, who again is a preeminent litigator and is famous for a number of cases, most notably the Janet Jackson, Justin Timberlake 2004 Super Bowl wardrobe malfunction case, which you may be familiar with. We could talk about that a little later. So these are the individuals who are in the book in terms of the conversations. And they're really, I think, very rich conversations. They're not dry conversations. There are no footnotes. And I think, again, the idea is to have one volume where if someone wanted to ask you or ask, I want to learn more about the First Amendment, particularly free speech and free press. Can you recommend a book in this area? Hopefully this is going to be the book that people will recommend. It's what I call an evergreen book, which means that it's not meant to sort of focus on really current controversies that will be outdated in a year or two. So there's not a lot of Trump discussion in the book. It's a book, hopefully, that we'll be able to use 5 years from now, 10 years from now, 15 years from now. That's why it's called The First Amendment Lives On, because the First Amendment literally does live on.
You mentioned this idea of a journey, and I was reading in your book the interview with Floyd Abrams, who incidentally made a talk here on campus 10 or 12 years ago. And I thought it was interesting, maybe interesting for these students to think about what did you learn from asking the question of where was the origin of people's passion and interest in the First Amendment?
Good question. So Floyd and Nadine Strawson, for example, were debaters in either high school or college or both. And I find that many of the people typically started very early or had something spark in their lives probably when they were teenagers. And I think Floyd is an example that he was a debater in high school, then, and particularly at Cornell, was a college debater. And Nadine started in high school and also was involved in college debate. And then we have another group like Lucy Dalglish or Bob Corn Revere, who started off as high school journalists. And so they really came from this free press background. It's not to say that everyone in this field started that early, but I think often that is the spark. As I indicated in my personal journey, I started off as a high school journalist. And the reason that's important is because high school journalists have always had struggles in terms of what they can report, because high school journalists typically report to teachers and administrators, and those individuals usually don't want to have things that might embarrass the school or them individually printed in a newspaper, or obviously on social media now. And so there's always been a tension between what students would like to cover, particularly when they cover things that are outside of school, things that are happening in the community, and what the school would like them to cover. And so there's been a long history of students who have been punished or retaliated or suspended for doing so, and school newspapers which have either been canceled or they've been shut down, or they've been told that they can't have a particular story printed. So those sorts of experiences, if you have them as a high school journalist, as I had and many of the other people had, that tends to begin to sear a passion for the First Amendment and free speech.
That was exactly my experience, and a chance to go talk with some practicing journalists at Northwestern University when I was in high school. And I think the students also might resonate, the case of Tinker and Mary Beth Tinker, her brother and friend. Those kinds of incidents have happened at the high school level where students were trying to express themselves.
Absolutely. And in fact, Mary Beth has been honored with a First Amendment Award. And a number of years ago, she organized a national bus tour, basically going around the country to high schools to essentially tell her story for those students who don't know the story. But essentially, when she was in high school, she was protesting the war in Vietnam at that point, and in order to protest, wore a black armband, and she was suspended for doing so. That case ultimately went to the Supreme Court, and the Supreme Court found in her favor, namely that the symbol of putting the armband was in fact speech. And so a major precedent was set in that area.
So we had the armband, we had the burning of an American flag during the 1984 Republican convention in Dallas that led to Texas versus Johnson, right?
Right, right. And of course, we have the people who litigated the case talk about that in there. So Burt Newborn and David Cole have been involved in the flag burning cases. And these are very powerful cases because, again, the traditional notion of the First Amendment as speech didn't necessarily cover this idea of symbolic speech. And so much of how we communicate is not just through words, but through symbols like an armband or a flag. And so they can be equally powerful. And over time, the United States Supreme Court has begun to recognize that.
Perhaps students born in the 21st century might not fully grasp that enterprises such as Hefner's Playboy were available to readers to share legal pornography, as was defined by the Supreme Court in Miller versus California in 1973, at a time when there was no internet. There were very few options, right? Movie shows, peep shows. And so there was a cutting edge aspect to Hefner's enterprise, wasn't there?
There was, and again, that goes back to his First Amendment values there. But he thought that readers and viewers should have an unfettered range of exposure to printed materials, and he didn't think that government essentially should decide what people could read. And there was a long history, obviously, through the postal laws, where essentially if something was put in the physical mail and sent, you could be arrested for essentially sending this sort of printed matter. And over time, we had a number of First Amendment challenges, which were raised, ultimately successful, so that we now have this unfettered exposure to have those sorts of printed materials. Now, obviously, over the years, we also saw the Supreme Court begin to redefine what it thought was obscenity. And over the years, it's been expanded. And so there's, under the Miller test, there's a number of things you really need to find there. It's very difficult at this point to have a successful criminal obscenity prosecution under the Miller standards, particularly because one of those talks about it has to be judged according to community standards. And today, our community is essentially the online community, so that all of us have exposure to everything.
You mentioned some of the controversies that Hugh Hefner faced while he was a publisher of the magazine. Playboy also had clubs around the country. Remember growing up in Chicago, there was one on Michigan Avenue downtown. There was a television show, I believe, Playboy After Dark.
Mm-hmm.
But a lot of people even then objected to the Playboy centerfold. And I'm guessing in the 21st century with cancel culture and a lot of the controversies that have happened online, that there would be the same kind of objection to some of the content in the magazine.
Well, the magazine is no longer owned or in any respect controlled or touched by either Hugh Hefner or Christy Hefner or the family. It's a totally different enterprise today. So Playboy magazine still exists, but it primarily is a licensing organization. And if you travel around the world, you'll see Playboy cologne and Playboy candy and all sorts of things that have a logo attached to it. And a lot of money obviously is derived through licensing. So the magazine today is very different from what the magazine was, while he was running it, but it no longer is, under the same control. So it's really comparing apples to oranges. But when the magazine was under his control, he wanted to have a magazine that also embodied this diversity of ideas. And one of the critical aspects of that was what he conceived of as the Playboy Interview. And these were these interviews, as I said, that were conducted, but they were conducted with such a broad range of people in terms of their ideologies or their religions or their political affiliations. I don't think any other magazine or any other media outlet since then has exposed people to that diverse a range. So some of these names may be familiar, others you can look up, but there were people like Clint Eastwood and Bob Hope and William F. Buckley Jr. and George Wallace, who was the segregationist governor of Alabama, and William Colby, who was the CIA director. Madalyn Murray O'Hair was the head of Atheists for America. George Lincoln Rockwell, who was the head of the American Nazi Party. Jimmy Hoffa, who was a labor leader. Betty Friedan and Germaine Greer and Camille Paglia, who were feminist leaders. Anita Bryan, who was an anti-gay activist. So again, these were not necessarily people he agreed with at all. And in fact, in many cases, he really disagreed with these people. But the notion of the First Amendment is not to essentially pick and choose people based on who you support, but exposing readers to a very diverse group. And I think the interviews were really an embodiment of that concept.
I also think of the Larry Flynt case because Flynt was also a controversial character who people might have taken issue with for his style. And yet it's those type of uh, advocates of free speech that help define the First Amendment, don't they?
I think that's right, and yeah, the First Amendment is not always popular. Karen Tumulty is deputy editorial page editor for the Washington Post. She wrote a little comment about the book, and she really observed, which I think is correct, is the First Amendment is meant to make us feel uncomfortable, because again, it's not all the things that we agree with. It's a lot of things we don't agree with, but it's the ability of people who have those opinions we don't agree with to be able to express those. And of course, that applies to free press as well.
I want to get some student questions in here. Devin, did you have a question for Professor Brotman?
Yes. I would like to ask a question about your chapter in the textbook, the Communication in Law and Broadcasting, and how that relates to free speech. Like in the first sentence, you say broadcasting regulation is one of the most complex and dynamic areas of communication law. My question is, do you think with these like new technologies like streaming and such and more easy ways to have a self-expression, do you think broadcasting will not necessarily come outdated or something like that, but will broadcasting have to re-regulate for those means, or just stay kind of in the now, you know what I'm saying?
Well, it's a critical and ongoing issue, and one, in fact, that I spend a good deal of time in my conversation with Bob Corn-Revere. So some of you may know there's a famous Supreme Court case in 1978, the Pacifica case, where the Supreme Court essentially, for the first time, decided that the FCC could regulate this area of indecency. And indecency is distinguished from obscenity. Obscenity is in the criminal law. Indecency is not obscenity. It's another area, but and obviously it changes definition depending on the times. But at the time, in 1978, the Supreme Court said that the FCC could regulate what were known as the 7 words that you can't say on radio or television, which were derived from a recorded monologue by George Carlin, a comedian. That is still the law of the land in terms of broadcasting. So not only can't you not say those words, but there are a number of other restrictions that the FCC has had over the years. And the court in recent years has had 2 cases before it where they were able to, or at least had the possibility of overruling the Pacific case, but they decided not to under First Amendment grounds. And these were cases that involved what were called fleeting expletives, where you had essentially a live television broadcast where someone said one of those words in the course of accepting an award or saying a joke, and that wasn't bleeped out. And basically the FCC issued fines based on that fleeting expletives. We also had a fleeting image in a television program where less than a second of a person's bare buttocks was shown in a dramatic series, and that again raised fines for the stations. So in those cases, the Supreme Court decided that for other reasons, primarily procedural reasons, it would essentially strike down the FCC's application of the indecency standard in those cases. But it declined to take on the hard First Amendment case. And so the late Justice Ruth Bader Ginsburg, in a dissent, basically said, it's now time, with all the new developments of new technologies, it's not 1978 anymore. We really need to confront this anomaly of having indecency regulations in broadcast, but not in other media. So Bob Korn-Revere and I discussed what we call, or what he calls, the 5-screen problem. And I think that illustrates that you could be watching the same program on 5 different screens, and yet there would be different treatment based on the type of technology you were using. So you could have a monitor hooked up to a broadcast technology, getting an over-the-air broadcast signal. That's one screen. You could have a monitor hooked up to something that's connected to a cable. That's another screen. You could have a third monitor that's hooked up to the internet. You could have a fourth monitor that's hooked up to a PlayStation, a video game. And you could have a fifth monitor hooked up to a DVR. And depending on which monitor you were watching, there would be different First Amendment treatment. So obviously, if you were on the internet, you would not have that indecency regulation. The Supreme Court had another case, which is ACLU versus Reno, that it decided in the early part of the 21st century, essentially saying the internet is a very different medium from broadcasting, and in order for the internet to flourish, we really can't have indecency regulation. Supreme Court has also had another case which dealt with video game regulation in California. And again, the Supreme Court said that video games cannot be regulated for indecency. And then, of course, in the cable television area, because cable television doesn't use broadcast spectrum, you don't have indecency regulation there. So we have this very messy system that has now lingered on for many decades. And the question is whether or not the Supreme Court in our lifetimes will want to take up that case again. I'm not terribly optimistic, given the composition of the court, that there's any appetite for the court to take on, at least head on, the First Amendment challenge of whether or not you should continue to have indecency regulations in broadcasting. So does that sort of address what you're aiming at?
Yes, it does. Thank you very much.
Good.
Professor, I remember entering the broadcast news field in about 1977. And, you know, after the Red Lion decision and at about the time of the Pacifica decision, the Radio Television News Directors Association was calling the status one of second-class citizen in terms of broadcasters. And if anything, it would seem that that is even worse today, given the competitive landscape that you defined in the recent Academy Awards. The network did bleep out most of Will Smith's profanity, but you could turn to Twitter, and we did this a couple weeks ago in class, and hear exactly what he said, and it was a different context.
Right, and that shows you how ironic this all is, because clearly we live in the world where you don't need to rely on broadcast television anymore. I think most people, as soon as they saw that, immediately, if they weren't already online, immediately went online. And then also you'll notice that some of the feeds that you saw online were broadcast feeds, but they were outside the United States. So the Australian Broadcast Company, for example, aired it without bleeping out anything, and Japan did the same. So again, I think that underscores the anomaly of all of this, which is that people have exposure to it. And what's happened over the years, obviously, is there have been different interpretations. We now have what's called a safe harbor, and the safe harbor, which is enacted by Congress, that essentially says that during certain times of the day when it's presumed that children are not watching, there's greater flexibility, which is why sometimes you'll have some of this language in late night. But even there, you continue to have something called standards and practices in broadcasting. So even if it's allowable under the law, it's not permitted under the standards and practices of a network. So some of you who are SNL fans may remember Jenny Slate, for example. So Jenny Slate was on SNL, and she blurted out, obviously it was a live show, the first show that she was on, she blurted out in a skit the F word, which obviously did not get bleeped, and she was fired from SNL because of that, even though under the FCC's indecency standard, the FCC probably would not have done anything, but the network felt that they didn't want to go there.
It's interesting that over-the-air broadcast television, although it went digital, it's still, if you're thinking about the rationale for indecency regulation is to assist parents in protecting children from messages they don't want them to see and hear, it's not able to do what a Netflix children account does, which is basically allow parents to pick and choose the content. So you had labeling on the over-the-air broadcast networks, and I suppose in some cases you could set up via smart TV some blocking, but it required a lot of parents who wanted kids to not see these messages.
And we do have the V chip, which is part of our law that passed in 1996. And so every television set over 13 inches now has this little chip in there, which will work with that new television rating system. But in terms of actual usage, it's really something that virtually no one uses. And so it turns out to be a law that I think had more cosmetic impact than real impact. And of course, it only applied to television. So broadcasting covers radio and television. So you still have the issues of what to do about radio, even if you have the V chip or even if you have ratings.
Going back to Devin's question, I believe one justice, it might have been Justice Alito in one of those cases you mentioned, suggested maybe in oral arguments that why can't we just wait for this to go away as a problem, which sounded to me like over-the-air broadcast television might go away sooner than later. Is that kind of the sense you have of the court?
No, I don't. I mean, broadcast over-the-air broadcast television is still about 20% of the television audience. And actually, for some of you who may not know this, it's the technology, because it's digital now, you can get very small antennas which can receive a digital signal quite well. And so I think a lot of people, particularly people who were cord nevers or cord cutters, people who didn't want to buy cable, you could get over-the-air television quite cheaply. And if you want to have a local broadcast signal, there's no reason not to have it. So I don't think, certainly in our lifetime, that broadcast television is going to go away. And then, of course, we have radio. And radio, I think, remains a very dynamic over-the-air medium. The irony is, obviously, we have internet radio. We can get radio stations online, but I think the majority of people still listen to radio in an over-the-air broadcast mode. And part of the reason is because people are in cars, and cars have radios. And so I think as long as we have cars and as long as people are listening, obviously you can plug an iPhone into a car and you can stream and do a lot of other things. But I think broadcasting is here to stay. And even at a 20% level, we're talking about 65 or 75 million people in the United States. So I would disagree with Justice Alito if that's his personal assessment that broadcasting is going away.
So at the same time, if you want it more unfiltered, you're going to have to pay the streaming service, I presume. We do have a question that has come in. Do you believe people hide behind the First Amendment when it comes to controversial posts they make on social media? That's from Fatima. Okay,
well, I'm not sure I understand what the question is, but essentially, there are two aspects of the First Amendment. There's a legal aspect, the First Amendment law. The law basically follows the First Amendment of our Constitution. And within the First Amendment of the Constitution are provisions dealing with freedom of speech and freedom of the press. And so over the history of the United States, particularly over the past 100 to 120 years, the United States Supreme Court has issued a number of decisions which essentially shape the contours of the First Amendment in terms of the law. That's separate from what we might call free speech and free press culture, which doesn't necessarily conform to the legal aspects. So the First Amendment itself is a prohibition of government interfering with the ability of someone to speak freely or to publish freely. And so the cases that deal with the First Amendment deal with government interference. Cases that deal in the free speech and free press culture may deal with government interference, but often just deal with people or organizations which are trying to prevent other people or organizations from speaking or publishing. And so I think it's important to distinguish the two between First Amendment law and free speech and free press culture. There is an overlap, obviously, but there's also a distinction between the two.
The students have looked at the terms of service and user agreements of social media platforms, and that leads me to a follow-up, which is, what is your take, Professor, on the congressional discussion about changing Section 230, revisiting the broad internet freedoms that came out of Reno versus ACLU, perhaps putting some level of restriction on these largest social media companies, such as what Texas tried to do in their legislation, in the view that they now have a fair degree of control over what is said or not on their platforms?
Well, I always start that discussion with what restrictions would be put in place. So there are really two restrictions typically that people talk about. One is the ability to sue a social media platform for something like defamation, which would be libel, or invasion of privacy, or intentional infliction of emotional distress. So right now, Section 230 of the Communications Act prevents the ability of someone coming in and suing a company on those grounds. That's one potential revision. The second would essentially create liability for companies in terms of refusing to carry certain content for whatever reason. So there would be a new liability potentially if you were denied access to have, let's say, a Twitter post or a Facebook post or an Instagram post. So those are the two areas. Now, those areas essentially have been dealt with quite comprehensively by the Supreme Court. So as you mentioned, the ACLU versus Reno case, I think the court was quite clear and, in some cases quite eloquent in terms of describing the internet as being a very unique medium. And so in order for a Section 230 revision to be successful, it would have to convince the Supreme Court that its reasoning in the ACLU versus Reno case was wrong. And I think that would be a very, very difficult argument to get the court to accept. So I think that's one area that it prevents. On a practical level, let's say the liability for social media platforms was lifted and you could sue one of these platforms for defamation. So let's talk about the practical import of this. You feel that someone who said something, let's say on Twitter, defamed you, and you want to sue Twitter because Twitter obviously carried that message and they didn't moderate it in some way. So it's essentially you as an individual now suing an organization, a company like Twitter. And on a practical level, it's really hard to imagine whether or not any individual is going to have the resources to be able to survive any of that litigation. So we even see in the major media area, networks, there are really very few defamation cases that are ever mounted successfully against a network or a major media outlet. So most recently, we saw there was a case that Sarah Palin, the former vice presidential candidate, sued the New York Times for defamation. That was one of the very few cases that actually went to trial. And of course, it didn't even successfully go to trial because that case was thrown out before any verdict was reached. It will be appealed. Ultimately, that would go to the Supreme Court. But in her case, because of the Times versus Sullivan standard for actual malice of defamation, it's highly unlikely that she will be successful. So I guess the net of all of that is, even if we had a lifting of Section 230 for purposes of having individuals sue media organizations, what practical effect would that have to deter any of that? And then the last Supreme Court precedent, which would have to be dealt with here, is a case called CBS versus DNC, which is a case in the 1960s when the Democratic National Committee decided they wanted to purchase an advertisement on the CBS television network, and CBS television network essentially refused them. And they went to the Supreme Court and said, wait a second, you can't do that because CBS is obviously a public trustee, uses the broadcast spectrum. But the Supreme Court said no, they are basically not in the position of having to accept your ad. So it's really hard to believe that the Supreme Court now would say to a Twitter or a Facebook or an Instagram, you have to accept a certain ad or a certain posting when they've already said for broadcasting that you don't have to. And remember that once upon a time, the three television networks had far more power than the internet platforms that we had today. So even if you add up all of the internet platforms, they did not have the dominance that CBS, ABC, and NBC had, which was something like a 90% dominance of audience. And even then, the Supreme Court said, we will never require a broadcaster to carry a particular ad. So I'm somewhat skeptical whether or not, even if you had a revision of Section 230, whether or not it could survive a constitutional challenge based on those precedents.
Cody has a question about Elon Musk. You want to ask that, please?
So yeah, I guess I thought I saw he owns like 7% or some, whatever the stock is in Twitter now. With the First Amendment, I know like Twitter's been blocking people or kicking people off Twitter for misinformation or whatever. You know, some people, other people's not. Do you think Elon Musk will make any, significant change, I guess, now that he's got a little bit of say in the platform?
Well, what happened in the past 72 hours, originally it was announced that he was going to take a seat on the board. And obviously, if he was on the board governs the company and has voting control. And so if he were on the board, it might make a difference. He could certainly persuade other members of the board. Right now, even though he's going to hold about 9%, he's not going to be part of the governing structure. And it's unclear why he decided not to be part of the board, but I think the optics of having someone with that much control sit on the board and begin to have to make some of those sensitive decisions, I think it led them to say, wait a second, this doesn't make sense. But he reversed himself within a matter of hours after they announced that. And of course, the Twitter has released a press statement saying, they think this is now a good thing. But remember again, Twitter is not the government. Twitter is a private enterprise. And so Twitter is not controlled by the First Amendment of the United States. May be influenced by our culture of free speech or free press, but there's no requirement that under the First Amendment, anyone has a right to be on Twitter. And of course, we have the former president who has been banned from Twitter, and that's created some amount of controversy. But what happened in that situation? He decided to start his own social network. And whether or not that's successful or not is not really a First Amendment issue, but clearly part of the First Amendment is having the ability to essentially have your own microphone. And he has his own microphone. It may not be as widespread or as popular as Twitter, but the First Amendment doesn't guarantee that once you have the microphone, you have the audience to listen to you.
Gotcha. I guess I never knew that. Thank you.
There is also, Cody, the separate Securities and Exchange Regulation issue of tweets that he has made that might be viewed as manipulating the stock price, right?
Yes. Mm-hmm. Right. And certainly, regardless of how you think about free speech, there are certain boundaries of free speech and free press under the First Amendment. I mean, for example, you cannot use speech to communicate a crime and then say, well, wait a second, the First Amendment protects me. And clearly in the area of regulating publicly traded companies, the government has an interest in having certain communication restricted. So there are many restrictions dealing with what's called insider trading. If you learn about something that's happening in a company and no one else knows about it, or only insiders know it, and you act on it, let's say by selling your stock or by buying a stock, that's prohibited by the Securities and Exchange laws. You can't then say, well, wait a second, it's my free speech right to be able to tell people, or my free press right to be able to publish that elsewhere. No, you can't do that.
We're running short on time, but is there another student question that we have not addressed yet this afternoon? Looks like Tristan has one. Are you raising your hand?
Yeah, I was just going to ask, I know we talked about defamation on Twitter and we talked about Elon Musk. And for my research paper, I've been talking a lot about defamation on social media. And I know that Elon Musk just recently had a big case where he was accused of libel. And I was just wondering if you're familiar with the case or what your opinions on it were.
I'm not familiar with that case, but what's interesting is, again, going back to this very famous seminal Supreme Court case, which is Times versus Sullivan, which essentially said when you have a public figure, in order for the public figure to essentially be successful in a defamation suit, they would have to demonstrate what's called actual malice. That's a standard which says that the media outlet either knew that something was false and essentially published it anyway, or they really disregarded even knowing whether it was true or false. So these are very, very high standards. And particularly for someone like Elon Musk, who would fall under this notion of a public figure, even though he's not an elected official. Clearly, I don't think anyone would say that he is a private individual. So what we've seen over the years is that as more celebrities step into the spotlight, they clearly are part of public figure definition, and therefore you have to prove actual malice. Again, that's the reason why you have very, very few cases that get prosecuted, that get brought by public individuals against media outlets, because that standard remains. Now, there are a couple of Supreme Court justices who say, wait a second, maybe we shouldn't have that standard anymore. Maybe that's too high a bar. But I don't think there's enough of a consensus at the Supreme Court now if a case was brought to them to reconsider Times versus Sullivan, that in fact it would be accepted by the Supreme Court. I think, again, probably in our lifetimes, we will continue to have the Times versus Sullivan standard.
Faith, do you have a question?
Yeah, but Gabby and Maya raised their hand before me, so they should get their questions answered before mine.
All right, let's go to Maya first then.
I was just gonna go back to where we're talking about the revision of Section 230 and ask, in your opinion, do you think it's even worth the time and the resources of the courts? Like we talked about, not many people are going to be able to even sue someone like Twitter or Instagram. So do you think it's even worth looking at doing?
Well, it has a certain, I guess, political appeal. I mean, it sounds really good to say, gee, we're going to make these companies liable. And so I think, clearly it has helped certain politicians in terms of being able to stir interest. At a practical level, I think, again, it's going to be really difficult. What's quite interesting is that in the past presidential election campaign, both of the presidential candidates, Trump and Biden, called for reform of Section 230. But of course, the reality is that in a very divided Congress now, and there's so many other pressing issues, it's virtually impossible to think that there's going to be any major groundswell of reform of Section 230. Again, because even if it was changed, that would lead to a challenge at the Supreme Court level. And in order for that law to take effect, it would have to essentially confront some of the Supreme Court precedents that I talked about previously.
All right, we're in the lightning round. Gabby, quick question.
Awesome. I know we kind of, going back, talked about that broadcast media isn't really going anywhere, especially in our lifetimes. But as some of us go to pursue careers in broadcast media, what are a couple of changes we might see as we start kind of going into the field?
Well, obviously, every person in the field now is in multimedia. So I think every broadcast outlet does not operate solely as a broadcast outlet. They clearly now are doing podcasting. They're doing online. Obviously, as we move into the so-called metaverse, we're going to see more broadcasters involved in augmented reality and virtual reality. So I think as a general matter, students now will be expected, and the great opportunity you have is you can literally train in all of these new services and technologies simultaneously. It used to be that someone grew up in a particular tradition like broadcasting, and then all of a sudden had to retrofit their learning and their experience into the online world. You don't have that barrier anymore. You're learning everything at the same time. And so you'll be able to go into any type of media environment with those skills. So I think it's a great time to really be learning and to go out and have careers in the field.
Thank you.
I second that. Faith?
Yeah, so mine's a little bit unrelated to everyone else's, but I looked at your LinkedIn and it says that one of your specialties is crisis management. And that just kind of like, I feel like I've heard about like what that is before, but if you want to just briefly talk about like what it is. And I'm also curious as to if you like got your job thinking I want to like be like a part of crisis management, or if like that kind of found you instead.
Well, we live in a world of crisis, and it turns out that a crisis, especially in the business context or even in the personal context, it can make or break a company. So if a company goes through a particular crisis, we now, of course, saw with Will Smith Will Smith is involved in a personal career crisis now. And so clearly he has a number of people involved in helping him to manage that crisis. Some of it is the external part, the public relations, the communication out to the world, but some of it is internal as well. So many people may not be aware, but Will Smith has a production company, and he has raised about $600 million in the past year for that company. Well, now his investors are saying, wait a second, you are jeopardizing the money we have invested by what you did at the Academy Awards. So now he has to manage the crisis or a crisis going on between the firms that have invested in him and what happened at the Academy Awards. So what we see in modern society is this constant eruption of crises, and clearly they're almost on a case-by-case basis when, for example, hacking takes place, or when a big company gets a lot of their data exposed. That creates a crisis in the company, creates a crisis for the customers, creates a crisis for the people in the company who are managing the technology, creates a crisis for the investors. It may create a diplomatic crisis. Some of you remember a few years ago that North Korea hacked into the Sony system because Sony released a movie which was critical of Kim Jong-un. And so it raises sometimes very large issues. So the area of crisis management has always been an interesting one. I think it's more dramatic these days. And particularly, I think it really depends on people who have really good either communication skills or an understanding of communication, because at all points in a crisis, you need to be able to communicate. And so I think people being trained in communications tend to have some good career possibilities, but also I think some good training in this area. As I indicated, I started in government. I was involved at a very high level in government. Clearly, in government, there were all sorts of crises that went on during the period. And so I learned crisis management sort of on the job in my early career. And then I've continued over time as I advised private clients, and they had issues, how to begin to solve the issues. But they're a combination of communications issues and management issues. And for those of you who are interested, it's a whole new career path that I think might be a good one to investigate.
Our final question goes to Tanner.
Hi, I just wanted to say thank you so much for coming and speaking to the class today. My main question is like, I'm an advertising and public relations major, and I'm really into, in the book, in the chapter of like commercial speech and commercial law and all that stuff. I wanted to know, like, what's the regulations behind commercial speech through like broadcasting and like social media? Because in the book, I saw like a bunch of like law cases in the Supreme Court, and it's mainly about like picket signs and stuff like that. And there's one over like alcohol sales and stuff, but there's not really some over like social media and broadcasting. So I wanted to get your opinion on that.
Well, Congress created something called the Federal Trade Commission, and there's a law called the Federal Trade Commission Act. And so that meant that Congress delegated a lot of the authority, at least at the federal level, for this agency, which is sort of like the FCC. And within that agency, there's something called the Bureau of Consumer Protection. And they come up with regulations for certain types of advertising. Separately, there are sometimes other laws dealing with what could be advertised or how it could be advertised. And thirdly, sometimes the industry itself decides that they are not going to do advertising. For example, you don't see any hard liquor advertising on broadcast television, but you see it in magazines or newspapers. That's not because of a law, it's because the broadcast industry said, we don't want to be promoting this. But there is a law, of course, that says you can't have advertising of tobacco products on the air. And that's not because the industry said it, it's because Congress passed a law that said you were prohibited from doing so. So it's a very complex area in terms of what is regulated. There is this agency called the FTC. And so the first question to ask is, what regulations has the FTC enacted in a particular area of commercial speech regulation? And then obviously beyond that to see whether Congress has something in addition, whether the courts have decided, whether there's self-regulation. So it's complex. There's no really, I can't give you, sort of 3 or 4 easy guidelines in terms of what's regulated or not. And then of course we have with the internet the complexity that the advertising messages don't just reach the United States. So we have this whole other area of trademarks and intellectual property, but sometimes a trademark may be good in the United States, but you can't use it outside the United States, or sometimes a word in a trademark may be perfectly acceptable in one language, but when you translate it to another language, it may have an entirely different meaning. And so that gets very complex as well. So it's a great area. Again, I would say, study more, and certainly, again, there are really interesting opportunities.
Yeah, I would simply add that the FTC has to follow commercial speech law under the Central Hudson precedent, and that if you look at some of their enforcement actions, such as the Lord and Taylor case from 2016, you have the sense that in their newer guidelines, they're just saying you must be transparent. It must be legal speech. And beyond that, there's fairly broad ability to label advertising. I think one of the problems, and perhaps you would agree with me on this, Professor, is people using the hashtag ad or spawn or sponsor. It ends up being out of the opening view on Instagram and other sites.
That's right. And of course, we have political advertising. So we have regulations, actually a law, which requires when you have a political ad during the campaign, you have that famous tagline at the end, "This is paid for," or "I endorse this message." And of course, we have this whole other world of the the Food and Drug Administration. So when we have prescription drugs, you have to be transparent in terms of saying what the potential side effects are. So there are these really interesting and large pockets that have been carved out for separate regulation. But again, yes, I agree. All of those regulations still need to be consistent with the First Amendment, which means that by and large, more transparency rather than less.
If you go to ftc.gov and you scroll through their enforcement actions, you'll see a lot of their time is spent on deception and fraud. And there are a lot of fraudsters out there doing a lot of, sort of bad actor behavior, and consumers get hurt by that. And that's what they're trying to regulate.
Yeah, and even at the state level, there are comparable state agencies. Typically within the Attorney General's office, there's a consumer protection office. So something may happen in a state and that organization may investigate it, as opposed to the FTC. And sometimes it's both of those agencies, the state and the federal.